If hiring a new lawyer for your appeal is not in and of itself necessarily significant, publicly firing your trial lawyer kind of is. Let's talk about it. So in the public statement released by Ballard Spahr, we also learned that in addition to her adding lawyers to her team, Amber Heard has jettisoned Elaine Bredehoft. We have a statement from Elaine as well, in which she says, "This is the perfect time to pass the baton. I have pledged to Amber and her appellate team my complete cooperation and assistance as they move forward on a path towards success." Well, I find this quite remarkable because if there's one thing that is really unnecessary, it's the public termination of your representation. So let's talk a little bit about attorney withdrawals and what this actually means. So from a practical standpoint, Elaine being withdrawn from representation really just means that her name is no longer going to be on the signature form for documents that get filed in the case. It's an interesting choice because it's not necessary. You're perfectly able to hire new lawyers and add them to your team without getting rid of your old ones. Just if there is nothing for her to do, she wouldn't presumably be billing for anything. But there's nothing inherently wrong with keeping your existing legal team. Their names continue to appear on your pleadings. So this choice to remove her is a little bit telling. I suspect there are a couple of reasons why this could be. Let's start by looking at the rule of professional responsibility that deals with attorney withdrawals. And so what we see, first off, there are mandatory withdrawal situations and there are discretionary withdrawal situations, basically meaning under these circumstances, the attorney has no choice. You've got to get out of the case. And under these other circumstances, it's up to you to decide if you really want to or not. So mandatory withdrawal situations include continued representation is going to result in a violation of the RPCs. That can be a situation where a conflict of interest is going to emerge. It could be a situation where continued representation is going to require, let's say a misrepresentation upon the court, something along those lines, that because you can't do that, your alternative is to get out of the case. Second situation, the lawyer's physical or mental condition materially impairs the lawyer's ability to represent the client. We have no reason to believe that Elaine is ill or has mental problems in any significant way. Number 3, the lawyer's discharged. Client fires you, you're out. It's done. You no longer have any say. So there are other situations, though, where you may choose to withdraw, but it isn't going to be required. And so those typically involve situations where there are personal conflicts, perhaps moral conflicts. You don't like what the client is asking you to do. The client isn't paying your bill. These are situations where it's not inherently required for you to get out, but it's understood that you might want to. And so the rules give the attorney the right to be able to withdraw under those types of circumstances. The rule also lays out what the requirements are by the withdrawing attorney. in terms of this cooperation that Elaine has pledged to Amber and her new legal team, the lawyer does have an interest, an obligation to maintain the continuity of the representation, to make the transition smooth. And so they are required to do what they need to do to protect the client's interests. So, for example, if you have funds that you're holding that have not been earned yet, like a retainer type of deposit, you have to return those. You also have to assist in transferring your files and your records to the new attorney. Virginia's rule is fairly specific and thorough about what this looks like. So I would say we can assume from the statement by Elaine that she intends to fulfill these obligations to the letter. Does she intend any more than that? Well, she didn't pledge it, now did she? So the rule gives us the circumstances for when withdrawal is required and when it's mandatory. We don't know what circumstance applies to this particular situation, but we can certainly speculate. One possibility is that because we've seen this emerging insurance litigation that raises some questions about who is paying for Elaine, the representations made about who is paying Elaine, these can potentially give rise to conflict of interest types of situations. Elaine may be called upon to explain her basis for eliciting that testimony from Amber Heard that she had paid for $6 million in legal fees. As Amber Heard's attorney, that is bound by confidentiality, but to the extent it implicates her own ethical considerations, and in fact, she may be under a duty to do that as a result of a court order arising from this type of litigation. Not saying there is one, I'm just saying hypothetically that could happen. Those would create a conflict of interest situation, and so that would necessitate Elaine no longer being able to represent Amber. Certainly possible that there may be personal conflicts. We have seen Amber already fire 2 sets of attorneys when she didn't get the outcome that she was looking for. Her first representation in the case was by Eric George. He had moved to dismiss the case or have it transferred to California. That was not successful. After that effort failed, she then hired Roberta Kaplan. Roberta Kaplan sought to get the case dismissed on the grounds that essentially it didn't adequately plead defamatory statements, that the comments that Amber made in the op-ed were not actionable for a variety of reasons. And that motion was also not successful. And a short time later, Roberta Kaplan was also fired and then replaced with Elaine Bredehoft. So I suppose in that respect, maybe it's not surprising that once Elaine Bredehoft failed to convince a jury that Amber Heard was not lying about all of the abuse that she described receiving from Johnny Depp, that Amber Heard would act consistent with this pattern and be done with Elaine Bredehoft as well. Certainly possible, plausible interpretation of the events. What I do think, though, that we can infer from this very public severance of that relationship is that it is not amicable. There is no reason to need to make this announcement. If it's kind of a technical decision anyway to remove a lawyer from the team rather than simply just adding on new ones for the new task, there is even more of an implication of what is going on behind the scenes that comes to light from the need to announce it, to make it clear we're done, we no longer have this continuing relationship. So many of us predicted long ago that once Elaine's role in this case was done, it would be under the tires of the bus with her. And I think what we see from this statement is indication that that is very likely to be the case. So a question that a lot of people have had in light of that is, does that give Amber an advantage on appeal? Is she throwing Elaine under the bus so that she can blame Elaine for the outcome? She made mistakes. She did things wrong. She was a terrible lawyer. It wasn't fair. I didn't have good representation. Therefore, I should get a new trial. And so the answer for that is very simply no. Ineffective assistance of counsel is not a basis for appeal in civil actions. The whole idea of ineffective assistance of counsel comes out of criminal law. But criminal cases are a little bit different because we have a Sixth Amendment right to counsel that specifically applies to criminal prosecutions. And so as a result of the Sixth Amendment, the U.S. Supreme Court has held that in a criminal case where a person's life or liberty is at stake, they don't have a realistic prospect of being able to defend themselves when they are up against a seasoned lawyer representing the state. So in those types of circumstances, it's simply you're so outmatched that it's not going to be a fair process. And so that's why the founders specifically created that right to counsel in the Sixth Amendment for criminal cases where those fundamental interests of don't put me to death, don't lock me in a cage are at stake. That rule was first recognized back in the 1930s. It subsequently was applied to the states in this landmark case known as Gideon versus Wainwright. It's still the same principle. The Sixth Amendment gives special protection to criminal defendants when it comes to their attorneys. And so as a result, not only do you have the right to have an attorney appointed, you have the right to a competent attorney. So this is very distinct from the situation in civil cases where in some circumstances there might be a statutory basis for giving you an attorney, but by and large there is no constitutional right to an attorney in a civil case, with a few limited exceptions for situations where similarly fundamental rights are at stake. And examples of those are situations where the state wants to put you in a psychiatric hospital against your will. The state wants to strip you of your rights to parent your children. These are situations where, although the proceedings are technically civil, because they involve important human rights, these are situations where there has been recognized to be constitutional interest in evening the playing field by requiring that counsel be appointed to the defendant. But in your average run-of-the-mill civil case, you don't have that right. And case law has made this very clear. I have chosen for an example here this case out of the Eighth Circuit Court of Appeals. So this arose from what's called a 1983 lawsuit. This is a specifically statutorily authorized claim for people to sue the government, essentially, for depriving you of your civil rights. So this is often used in situations where there's been an unlawful arrest, there has been excessive use of force, those types of claims against the government. And that statute specifically provides for circumstances where the district court can appoint counsel to represent somebody, but it's not required. And so in this particular case, counsel had been appointed, but the defendant, or in this case, the plaintiff, was unhappy with how the attorney was performing, didn't like the job he was doing, basically, and so had asked for a new attorney to be appointed. And the court in that case made it very crystal clear, no, that's not the standard in civil cases. You don't have the same type of constitutional protection for your right to counsel that you have in criminal cases, because of the Sixth Amendment being the source of that criminal protection. So essentially, in a civil case, your right to counsel is that you have the right to hire one. They can't close the courthouse door on your attorney. If you want to be represented by an attorney, you can't be prevented from doing that. But that's pretty much where the line is drawn. You get to choose your lawyer. And so there are upsides and downsides to that. In Amber Heard's case, she wanted a particular skill set. Perhaps in retrospect, there were downsides to that maybe she wishes she didn't take on. But that was her choice. She was free throughout the process to replace Elaine, to discharge her. As we have seen, Elaine would have no choice but to withdraw if Amber fired her. And she chose not to do that. So ultimately, the consequences of that are on her. The remedy for being unhappy with your attorney in a civil case, their underperformance, negligence, whatever, is to go sue them for malpractice if you think you can make that showing. But that is not going to disturb the verdict in the underlying case that the attorney allegedly messed up. So we have this colloquial expression when we talk about withdrawals, distinguishing between a quiet withdrawal and a noisy withdrawal. Now, 99% of the time, if not more, the only responsible, ethical way to withdraw from representation is quietly. And the reason why is quite simple. You have duties of loyalty and confidentiality to your client. You must continue to maintain those even when the relationship is severed. So, as much as you might like to rant and rave about what a nightmare it was to represent this particular client and tell the world about all of the difficult things that they did behind the scene and just what an awful experience it was, you don't get to do that. Those are part and parcel of the responsibility of being an attorney, that you cope with those in your own way and you keep it to yourself. So a lot of times when you see attorney-client relationship breakdown that goes real bad, that can lead to like ethical problems, things like that, it's often in the context of a noisy withdrawal, meaning the attorney says a little bit too much about why they are getting out of this particular case. So I do find it really telling here that Elaine, she actually pulled off a move here that is far more subtle than I think I would have given her credit for. So kudos to you, Elaine. She has managed to pull off the quiet withdrawal that nevertheless speaks quite loudly. And I refer, of course, to this choice of language, this pledge that she has given to Amber Heard. You know, there's a lot of words you could choose to use in this communication. Pledged is not a word that I think is commonly chosen for this type of situation. You might say, I commit to, I undertake to, I promise to. Pledge, though, pledge, just like Amber Heard pledged. Oh, it just brings back all of those credibility problems that Amber Heard has had with her case for so long. Is Elaine telling us, she knew all along? Because we know you knew, Elaine. We know you knew. Thank you for joining me for this conversation about the significance of Elaine's termination from the case. I'm going to be turning next to looking at some of the specific arguments that we might expect to see on appeal, given the information that we can ascertain from the Ballard Spahr's public statement. So join me in the next one.